Good morning students, this is Nilofer, Miss, your SS teacher. Today we are going to continue with the chapter 8, Framing of Constitution and its Features, part 4. In this video today we are going to complete our chapter. Okay, so here the first point for the chapter is residuary powers. What is residuary powers? That we are going to know about in these 3 points. We'll understand about it in these 3 points. So the first point, the subjects which are not specifically allotted to union or state are included in residuary powers. Some of the points are there which are being not discussed by union or state. It means union or state, both of them could not take decision on some of the issues, some of the points. So these points which are not being handled by union or state, that power is those issues are included in residuary powers. See, matters that are not included in the division of powers are known as residuary powers. See, it means the powers are already divided between union or state, but some powers left even after dividing. So while division of the powers, while doing the division, while dividing the powers, some powers are not allotted to any one of them, neither to union nor to state. So those powers which are not included in the division of powers are known as residuary powers. So the central government is given the power to legislate on these residuary subjects. So where your union is not working on it or state is also not working on it, so these subjects are looked after by the central government. The central government is given the power to legislate on these residuary subjects which are not included in the division of powers to union or state. See now financial distribution. Now financial here means money. From where is this government getting money? Here government is not going to any job to work. Okay. So they are from where this government is getting the money. What are the resources for getting money to government? The financial distribution of resources is done between union government and states governments. The financial distribution of resources is done between union government and state governments. It means some of the resources, these resources are divided between union and state government. So, see now which department is given to whom? Excise and custom. First of all, excise and custom means what? You must have heard about the duty. The things which are importing from outside, they have to pay duty on it, they have to pay tax on it. Then export import, it means some of the things, some of the trade that which the business is done between our country and other countries. So the things which are going out of the countries and the things which are coming from outer countries, so on that also we have to pay the tax. Then income tax, all these major taxes, these are the big taxes, are decided by central government. So central government is collecting all these taxes, in which excise and custom, export import and income tax. Okay, so you have to remember excise and custom, export import and income tax. These 3 taxes are collected by central government, and this is the resource of finance of central government. From these taxes central government is earning. Now state government, so sales tax, revenue tax, entertainment tax, educational tax, which are having meager financial resources, are decided by state government. These local taxes, it means first sales tax, then revenue, then entertainment tax, as we are watching movies and TVs, all whatever the entertainment things are there on which we are paying the taxes. So those tax and educational tax, in the school you are paying the extra money which are being collected by state government. So these all taxes are collected by state government, and it is the resource of income for the state government. See now we are going towards 5th feature. We have already learnt 4 features, then we have learnt about residuary powers, and now we are going to 5th feature. Which is the 5th feature? So unified arrangement during crisis. So when crises are there in the country, crisis means here bad condition, very poor condition. It may be related to finance, it may be related to war or something else. Just now we are even having crisis related to our health. So if there is any kind of crisis, during this crisis unified arrangement is done. There are three provisions for emergencies in Constitution of India. So three provisions are given for these kind of emergencies. So which are they? So first point, national emergency can be declared at the time of war, external attack or armed rebellion. So if there is a time of war, if we are in the condition of war or external attack or armed rebellion, so that time national emergency is declared. It means all transportation is closed. You will not get anything. Even you will not get the milk. That is the worst situation when national emergency is declared. See the next point. Due to law and order breakdown, the state cannot function according to the constitution. So constitutional emergency is declared. It means in our state or in our country, law and order breakdown starts. Maybe the people come on road, they started burning the buildings, or they are not listening to the law. That time this constitutional emergency is declared when nobody is listening to the law that time. Then the third one is financial emergency. So due to increase in prices, when the prices are increased on all the things you are buying, that is monetary value erosion. For example, you are going somewhere to buy a bread, okay, and you are taking out 50 rupees and you are telling that, see, take 50 rupees. Then the person will tell 50 rupees, no, this bread you have to, if you want to buy, then it is of 100 rupees. So you will say, oh, it means when the value of money erodes, get down, that time, and the prices are increased. So that time this financial emergency is declared. So these, remember, three kind of emergencies are there. First is national emergency, we just talked about. Second is constitutional emergency, and third one is financial emergency. During the time of war, external attack or armed rebellion. Here armed rebellion means when our own army is working against us. These army work according to themselves, they are not listening to the nation. So that time national emergency declared. And then the other one is constitutional emergency. It means when the people are not listening to the law, they are working against the constitution, they are not listening to police, they are doing the task not related to constitution and against the constitution, then constitutional emergency is declared. And the third one is financial emergency, when the price is increased and monetary value decreases or erodes. That time financial emergency is declared. So when these kind of emergencies are kept, so who will work that time? So the central government. The central government has been given more powers to deal with these emergencies. A central government will look after all the states. There won't be any state government taking the decisions. All the decisions would be taken by the central government. At the time of emergency, India is almost turned into a unitary system. It means one only government, the central government. No other sub-governments would be in working order. Only central government will take decision, and you have to hear that. Only central government would be in the power that time. Our next point is sixth feature, bicameral practice. Now what is bicameral practice? Let's see. India has a parliamentary system in governance. What we are having here in the government? We are having parliamentary system. In a parliamentary system, the parliament is a supreme authority representing people. Here parliament is only the supreme. The people to whom we selected, we choose by our vote, those people are there in the parliament and they are representing us. They are representing people. So these people are the main people here, as we have only selected from there, only PM is also there. So these are the people, they are having the supreme authority of the country. See the third point, the legislature at the union is a parliament. What is parliament? The legislature at a union, at the central. All these people whom we have selected, they sit together over there. That is parliament. Now the parliament is bicameral, means it has two houses. Okay, two houses are there in parliament. One is upper house, the second one is lower house, and the upper house is called Rajya Sabha while the lower house is called Lok Sabha. See after this, though the government is carried on in the name of the president at the union and the governor in the states, actual administration is carried by the council of ministers headed by the prime minister at the union and the chief minister in the states. See, the paragraph is lengthy, but it is so easy, I'll explain you. See, there are two parts of the government. One is central, the other one is state government. So here in the central, the government is run on the name of president, while in the states, it is running on the name of governor. Remember, at the central level, president, while at the state level, governor. But also, at the central, the council of ministers, in which their head is prime minister. They are working in the central, they are running the government, while in the states, the council of ministers with them chief minister, it means CM. These people are working in the state government. Remember, in the central government, council of ministers plus PM, and at the state level, council of ministers plus CM. The council of ministers is responsible to the legislature that comprises representatives of the people. Here, council of ministers, those who are, they are responsible to answer in the parliament. They have to solve all the issues in the parliament. They have to answer the people. The next point, the president selects 12 people who are experts and experienced from various fields for Rajya Sabha. See, the people in the Rajya Sabha, they are elected, but only 12 people are there, those who are not elected. So what they are? They are being selected. They are selected by the president directly. And these people are experts and experienced, and they are from various fields of Rajya Sabha. Now next point, Rajya Sabha is a permanent house in which 1/3 members retire every 2 years, the same number of members for election. See now here, Rajya Sabha is never dissolved. It is always there. It is a permanent house. And every 2 years, they are having elections for 1/3 members, those who are retiring. 1/3 members retire every 2 years, and then in the place of them, other 1/3, other people are elected. Thus, each member has 6 years of tenure in Rajya Sabha. It means states of Council of States. Here, the time period for their working is of 6 years. Each member is getting 6 years to work here. The power of Rajya Sabha are less compared to the Lok Sabha, which is special, superior and decisive. It means Lok Sabha is having more power. Okay, it is special, it is superior and decisive. Rajya Sabha is not having that much power. But yes, the point is Rajya Sabha cannot be completely dissolved. But Lok Sabha dissolved every 5 years, then other people come at that place. New government comes at that place and then it sits to rule, while Rajya Sabha cannot be completely dissolved. Here is the 7th feature. It is about the judiciary, our courts. See, independent, impartial, integrated judiciary. First point in that, the Constitution has provided for the establishment of an independent and impartial judiciary. We have learnt about this. Okay. Next point, there is Supreme Court at the top. Then there are high courts at states, and under its jurisdiction are the district courts at district level, and at the taluka level there are local and special courts. It means taluka courts. I think this is very much clear. We have already learnt about Indian judiciary, in that we have discussed all these topics. So you may go there once again if you want to make clear. See, our judiciary is impartial, it is independent. Secondly, Supreme Court is the highest court at the top. Then high courts work at the state level, district court works at the district level, and taluka courts works at the taluka level. Next point, the judgments of Supreme Court are binding to all the subordinate courts of the nation. It means whatever judgment is given by the Supreme Court, so all other courts have to respect that. You can't go against that judgment. Next point, In case of conflict between the union and the state governments, matters related to constitution and interpretation of statutes, the final decision is vested with Supreme Court. Statutes here means law. It is the other name of law. So if there is any matter between, if there is any fight between union and state governments, or there is any matter relating to constitution and interpretation of statutes, it means law. So the final decision, who will take the final decision for that? So the Supreme Court will be the authority to take the final decision, and nobody else would challenge it. The decision taken by Supreme Court can't be challenged. 6th point, the Supreme Court is the protector and guardian of the Constitution, which we have already learnt. You can say the bodyguard of the Constitution. Nobody would harm the Constitution. The protector, the guardian, it is the Supreme Court. 8th feature is amendments in Constitution. It means you can make the changes in the Constitution. See, in the first point, compared to other countries' Constitution of India is dynamic. Dynamic, see here, dynamic word is given. Dynamic means here progressive or changeable. But it doesn't mean that you or me can go there, let's go to Delhi, I want to change the Constitution. No, it isn't like that. How to change the Constitution? There is the process for that. A common person can't go there to change the Constitution. So here, see the second one. Constitution can be amended as and when required. When there is requirement, constitutional provisions can be amended in 3 ways. There are 3 ways how these changes can be made. So see the first one, how to make the changes in the Constitution. So amendments can be made by a simple majority of members present and voting in the Parliament. So voting will be done in the Parliament by the members of Parliament, and in that simple majority will be seen. According to that, the change can be made. So amendments can be made by a simple majority of members present and voting in the Parliament. Second one, certain amendments require a special majority, that is 2/3 majority of members present and voting. See, in the first one we have talked about simple majority, while certain amendments, some changes are there which need special majority, in which 2/3 majority should be there of members present and voting. Third point, concerning the union-state relations, the special majority, that is 2/3, and the concurrence not less than 50% of the state legislature is required. See here, concerning the union-state relations, if there is any matter which affects the union or the state government and the relations, that time the special majority, which is 2/3, as well as with that the concurrence not less than 50% of the state legislature. Here we are having 29 states, and if this change is going to affect the states, then not less than 50%, it means at least 50% state should be giving concern towards this statement, towards the decision, towards the change, then only the changes can be made. See the next point, if there is any amendment to be made in the interrelations between union, state structure of or in supreme judiciary. So here, if we are making the changes related to union or state, or if we want to make the changes in the supreme judiciary, then what is needed? Then at least half of the states from the total states have to give consent. They must be ready, they must be saying yes. Half state, at least 50% states should be in the consent, then only you can make these changes. Next point, next is judgment of court can also bring amendment by the Parliament. So through the Parliament you can even change the judgment of court. There will be no charge in the basic structure of the Constitution. There will be no change in the basic structure of the Constitution. The basic features are there, the basic structure is there. That won't be changed. You can't change the basic structure of the Constitution. Simple majority in parliament can bring change in the amendments of the constitution. Means small changes, very minor changes you can make by simple majority in parliament. That's why the constitution is known as the most inconstant. Inconstant means it is not that once written and it is going that only. No, you can make the changes in it, and so it is known as most inconstant and flexible document. But at certain cases it is not amendable by simple majority. We have just seen that some of the cases are there in which you can't change by simple majority, and even the basic structure is never changed. Without the majority consent of states, it's not amendable. Consent means permission. Without the permission of states or without the majority permission of states, you can't change it. Then two, the mixture of both makes the constitution. When you want to make the change in the constitution, both, it means state and union, both are needed. Together they can make the changes which is required. Next is ninth features. These features are going very far now. But yeah, it is easy. Universal adult suffrage. What is universal adult suffrage? Adult suffrage we have already learnt. Again we will repeat it. In India we have a system of adult suffrage which is flexible. Okay, here adult suffrage is also flexible. According to that, any citizen who is above 18 years of age, who is of 18 years and above possesses right to vote in the elections of the parliament. That person who is above 18 years can vote in the parliament. He or she can vote in the legislative assemblies or local self-government, it means panchayats, without any discrimination. There won't be any kind of discrimination. Only the point to be noted is that person should be 18 years of age and above. Okay, without any discrimination of education, property and economic standard. It doesn't mean that a person, if he is not educated, then it will be said that way you are not learned, so you just go away, you can't vote for the person. It isn't like that. There won't be any kind of discrimination related to education, property, whether you are rich or poor, you can vote, and one person, one vote, and economic standard. Okay. Next is 10th feature, secularism. We have already learnt this also. Let's repeat it again very fast. We have discussed earlier about secularism in the preamble. In the constitution, India has been declared as a secular state. People of different religions reside in India. Therefore, the state cannot discriminate any citizen on the basis of religion. No citizen can be given special rights or cannot be deprived of certain rights. Here secularism, we have already read, it is about the religion. A person can follow any of the religion, he can or she can have faith in any of the religion. Nobody would force the person to just obey to follow any one of the religion. Neither there are the rules or regulations related to the religion. There won't be any kind of discrimination on the basis of religion. Or no citizen can be given special rights, that if you are in this religion you will get this special right. No, it isn't like that. Or cannot be even deprived, that if you are in this religion you will not get these things. It isn't like that. All are equal. Secularism is there in India. That is our 10th feature. The state has to be absolutely impartial and neutral in respect of religion. Only secular state can offer proper or equal treatment towards all citizens. Okay, secularism means that the state doesn't interfere in matters of religion or is biased to any specific religion. The state has to be secular and indifferent. Followers of every religion are free to follow and practice their religion of choice. That is the secularism. Next is judicial review, our courts. Which things the court has to keep in mind, okay, or what power is the court having and what things the court has to judge. So judicial review is the chief characteristic of the constitution, as we know that Supreme Court is the guardian of the constitution. Okay, judicial review administers the working of union and state within jurisdiction. It means in the limit of that jurisdiction, union and state are working properly or not. That is to be reviewed by judiciary. Without disrespecting the powers of parliament. It means the power of parliament are kept in mind. It should not be disrespected. Keeping this thing in mind, the constitution has made an effort to harmonize the principles of judicial review. So judiciary and this parliament also, they should work in harmony. So these things are kept in mind while making the rules in the constitution. It can be asked in 1 mark that what is the chief characteristic of the constitution? So you have to remember judicial review. Parliamentary amendments, it means the changes which are made by the parliament, external orders, which orders are done, ordinances and judicial judgment are given for judicial review. These all things are monitored by judicial. It means the rules passed by the government, like for the traffic rules or for the taxis or whatever, or the judgments which are given by the lower courts, everything are being eyed by judiciary, Supreme Court. Okay. If the court finds any discrepancy in the external orders, ordinances or judicial judgments, it can stop them by declaring them unconstitutional. While keeping an eye, while judging them, while monitoring them, if Supreme Court finds that something is wrong, something is against the constitution, something is against the law, then those judgments, those orders can be stopped by the judiciary and it can be declared as unconstitutional. This judiciary can declare them that it is unconstitutional and it should be stopped now, and then the others have to follow it. Next is 12th feature, fundamental rights and duties. So here came the main point, fundamental rights and duties. If you are born in India, we must get the rights. These fundamental rights, who is giving us these fundamental rights? So constitution is giving us. Fundamental rights are conferred to the people of India by the constitution. Why these rights are given? To live a dignified life, to live a respectable life. Okay. The most valuable capital of our country is in the overall development of nation, which further lies in the fundamental duties and rights. As we are getting the rights, there are some duties also as the citizen, which even we have to follow. So these most valuable capital of our country, what is it? It is development of nation. This thing is kept in mind that development should be there of the nation. While keeping the development of nation in the center, such fundamental duties and rights are given. Right to constitutional remedies, and for the children 6 to 14 years of age, right to educate are also made available. Constitutional remedies means here, if your rights are being harmed by somebody, okay, if you can't enjoy your rights, so against that, these constitutional remedies, it means Supreme Court will help you out. And the other one is right to educate. It means the children from 6 to 14 years of age, they are having right to educate, and so free education is also provided to them. 13th feature, directive principles of state policy. It means whoever the government is, okay, then how to run the country, how this government will work in the country. Those principles are known as directive principles. See the first point in it. Protection of people, security and welfare should be carried out by the states. Whatever the rules are made by the state, whatever duties the state is doing, whatever changes the state is making, so state should keep in mind first the protection of the people, the security of the people and the welfare of the people. The principles provide directions for state governance and policy making, so they are called as directive principles. These principles show the direction to the state government. Okay, they are showing the way to the state government that how to make the policy while keeping protection, security and welfare of the people in mind. So as they are providing them the direction, these are known as directive principles. See now 14th feature, provision for backward sections and tribes. See the people, those who are in the backward section or who are the tribes. So to uplift them, okay, to make them walking together with the other people, some of the provisions are made. So here the first point, to uplift and include backward sections and tribes and deprived class in the mainstream, okay, together with all citizens are equal in India, but so to include these backward sections with the other mainstream, there are specific provisions in the constitution. Which are they? See, reserved seats are allocated in legislature and local self-governing bodies election to provide representation. See, in the local bodies, Lok Sabha, so here reserved seats are kept for these people so that the people of them, they elect them, and these people will sit at the reserved seats, and there they will be representative of their own people. They will talk about the problems of their own people. So the reserved seats are there in legislature as well in the local self-governing bodies, from where these elected people comes and they provide representation to their people. Which next opportunity is provided to them? So that is reservation quota has been provided for admission in educational institutes. It means schools. There is reservation quota for these people in the educational field also, and government jobs in proportion to their population to provide equal opportunity, so that these people, the backward people, should also get the opportunity to get the government jobs, to get good education. So these people also have reservation quota in the educational field also, in the government jobs also. Next one, children of backward sections and tribes are given scholarships, basic amenities and waived fees, which come under optimistic policies and shielding policies as per provision in the Constitution. Now these children, those who are in this school, the backward sections children, they are getting scholarships. Waived fees, it means maybe they have to pay very less fees, or government will pay their fees. These all schemes came under two policies, okay? Which are those policies under which this scholarship, basic amenities and waived fees are provided? So first policy is optimistic policies, and the other one is shielding policies. You have to remember these two policies are there under which these children are getting scholarships. Okay, then with this point I am completing my video here. You have to revise the chapter from your textbook. If you are having any doubt, any confusion, you may call me. Hope you have written the question answers in your notebook. If not written, just write down the question answers in your notebook and you have to learn it properly. Okay, stay home, stay safe. Thank you for watching.